सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों पर समाअत जारी है।
Procedures of the Supreme Court. My respectful question is, this para
statute which don't exist. If that is your impression, say it. That is my impression.
that is my impression.
So the law doesn't say this.
Right. So all the sections which are part of this Act 17 of 2023, I would go to Section 3. Any matter invoking exercise of original jurisdiction under Article 184(3) of the Constitution shall be first placed before the committee constituted under Section 2 for examination. And if the committee of the opinion that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Chapter 1, Part 2 of the Constitution is involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court of Pakistan, which may also include the members of the committee for adjudication of the matter. Regarding this Section 3, my submission is basically the legal authority already being part of the 1980 Supreme Court rules. This section, as a matter of fact, has been introduced by the Parliament, and I would respectfully say this is an encroachment on the area which falls within the jurisdiction, within the legal framework, I must say. So this is being in conflict with separation of power theory. My submission is this conflicts, and this is ultra vires, my lord, so far as this Section 3 is concerned, my lord. Shall also be available to an aggrieved person against whom an order has been made under Clause 3 of 184 of the Constitution prior to the commencement of the Act, provided that appeal under subsection shall be filed within 30 days of the commencement of the Act. This appeal has been provided in Article 184(3). My submission is this could have been done only if the Parliament had 2/3 majority. So this falls within the area of constitutional, I must say, competence of the legislature. So this is ultra vires the Constitution. So whereas Section 5 is concerned, until and unless there is 2/3 majority in the Parliament, this addition in 184(3) could not be done, and therefore this is against the separation theory as well as against the Article 39 of the Constitution, wherein 2/3 majority is a constitutional requirement for amendment in the Constitution. This encroaches upon the area I have just referred to. Regarding 6, my lord, I will just submit that the counsel which this is regarding review, the counsel who would be conducting a case before the Honorable Court would be suitable for the purposes of arguing the case while review is filed by a party. My lord, overriding of all laws, Section 8, read. The provision of the Honorable Court. So my submission is the total effort by enacting this law, which I am just referring to, effort has been made to enter into the area which is not within the domain of the Parliament, my lord. One thing I would be very respectfully submitting, that in parliamentary system, as a matter of fact, Parliament and the executive, they are the one. I must say, they are the same phenomena in the Constitution. They have a nexus amongst themselves. So therefore, I would say, and this has been so, I'll be just reading a line from my paper book, the condition which was prevailing at the time when this act was being, whether it was discussed, it is a question again, but when it was being passed by the Parliament, certain observations which have been reported in the press, that is very relevant for the purpose of understanding how this enactment was done and passed by the truncated Parliament, I must say, because it was not a Parliament indeed which had to go into the amendment of the Constitution. They had no authority to do so. I may just be allowed for a minute. Constitution Petition 20 and page, my Lord, I'll just read it for your...
Are you finding, basing your arguments on the basis of news reports in the Constitutional Court before the full court?
We don't have the...
You can't articulate the same thing yourself. As senior counsel, you have to rely on a news item, which may or may not be true.
My Lord, very respectfully submitted. No, my Lord, it's not me. As a matter of fact, we requested your lordships to...
I'm asking you a simple question you didn't write to the Speaker.
My Lord,
we are a separate constitutional body. Parliament is a separate constitutional body. If you want some information from the Supreme Court, for instance, would you write to the National Speaker? You would write to the Registrar of this court. Similarly, if you want some information from the Supreme Court, Parliament, whether they give it or not would be a separate matter. Freedom of Information Act 19A has now become part of the Constitution. If you don't bother to say, avail of this opportunity, please don't take this ground before us. Because it's a hollow ground. You haven't built on the ground yet.
Lord, certain records which are publicly available, and there is no reason to doubt them. So I think at times we have been referring these some of the news items for the purpose of understanding as to how certain acts or certain legal proceedings were taken. My Lord,
please, we will hear you, but we will not hear arguments of this nature. When you say, I will not write a simple letter and I will take up the time of the entire Supreme Court to